Now we're going to do another very interesting part that I just want you to see how difficult it is between the employer and how government more and more is interference. Because again, government has statute, and workers' comp is one of them, where they tell you what is safety. And of course you have OSHA and you have all the other agencies to make sure that the employer is liable for the injury of the employee in the course of employment. So then this question that I have here, is the employer required to provide safe working condition? And of course, right away, I know you're going to say, yes, he is required to provide safe working condition. There's a contractor relationship, and who knows better about the condition of your employment, whether it's safe or not. Now remember, we're talking about safety, not risk-free. Big difference. And who sets up the safety level? It's an agency of the government. And this is what I want you to keep in mind. So OSHA is a federal statute that requires employers to provide a safe working condition. It's a federal statute. The right to know is a state law. OSHA is a federal statute. That means every state has to have the same safety condition or safety standard. But then the question comes, what is a safe working condition? And I hear that many, many times. You know, sometimes I hear people say, I work in this office and the guy sitting next to me, he smells so badly. Is that a safe condition? One day I almost passed out. Or I hear some guy says, oh, this girl's, you know, she's a beautiful young lady, but oh, that perfume. I wish she would not wear that perfume. It makes me sick to my stomach. Well, is that a safe work condition? And this is where it's very interesting because we really do not know. And to start here, again, every time you go to a place, you're taking risk. We're talking about risk in your workplace. So here we go in another interesting case, Ekazabal versus Chevron. The court in this case had to weigh an individual willingness to risk his own health against the company efforts to ensure a safe working environment. Now, here's a situation where the company says to you, hey, you know, you're going to work in this department and you're going to be exposed to all kinds of chemicals. So I want you to know that this is a risky place. Well, as an employee, you say, oh, okay, that's okay. What's the chances of me, you know, getting sick? Oh, I'm taking a chance. First of all, you're so happy you got a job. You have a family to take care of, or you have kids in college or whatever it is, or you just graduate from college and finally after about 25 interviews, you got a job. And then he tells you, well, you know, you're going to be exposed to kinds of, and this is what I find the unfairness, because they don't say like, you're going to be exposed to this chemical. And since you're going to be exposed to this chemical, instead of giving you $40,000, we're going to give you $60,000. Then I would say, okay, so you got a choice. Because if you say, oh no, you know, I'm taking the extra $20,000, I'm taking a risk. It's almost like gambling, you know what I'm saying? Hoping that you don't get sick. But it's not that they're increasing your income. It's not that they're doing anything special because you're taking risk. So here's a situation that he had to make a decision, and the employer disclosed information. So assuming he had a complete grasp of the risk involved, he knew exactly, he was a chemist and he knows exactly, is it ethical to allow him to work there anyhow? The employer, I told you everything, I told you what you were going to do, I told everything what's going on. So in Ekazabal, why was the plaintiff willing to risk his health? That's one of the things that I want you to, while you're reading the case in your textbook, I want you to remember that. Why was he willing? And of course, it's a lot to do with some of the stuff that I explained to you just now. A person with limited skills and or opportunities might well be thinking of his family when he chooses the highest paying job he can get. People that are illegal immigrants, for example, they're leaving the family in Mexico, they're leaving the family in Russia or other countries, you know, they are so happy that they can work because in other countries they don't have employment. And they're willing to take the risk, even if they understand the risk. But then again, is it ethical? Probably the increased risk of a speculative future injury. Again, this is speculative. Does not mean that it's almost like smoking, you know, if you smoke, you may get lung cancer. Well, I know people that smoke and they don't have lung cancer. And then I know people that do not smoke that have lung cancer. So it's speculative. May be preferable to the known immediate harms on no job. It's more dangerous for you to have no job than take a risk that maybe you will not get sick occupationally. or one without health benefit, paid leave or salary adequate to feed, clothe, and shelter and educate one. So when you make that decision, which is better? Something that might happen or something that already will happen if I don't get the job and we're going to starve to death? What reason did Chevron then give for not wanting to hire Ekazabel? And this is very interesting because you see in the textbook the reasoning. And according to the court, it was a moral concern. In that situation, Chevron did not want to give him a job. I wish to avoid time lost to sickness, excessive turnover from medical retirement or death, litigation under state tort law, and the risk of violating the National OSHA of 1970. So these are the reasons that Chevron gave to the court while they will not hire this person, or it would be too risky for him to work in that situation, even if he was willing to take this situation. How can a company minimize the rock and hard place dilemma? Something to think about. Until the United Supreme Court overturned this decision, a company would not have been free to refuse to hire a person like Ekazabel. So this is something that I want you to be very careful in reading it. The United States Court overturned the decision of this case, and with another case, that's what it means. And a company would not be free to refuse to hire a person like it. They are not free. That means they have to hire the person, even if the company knows that it will be risky for the person to work there. In this case, instead of minimize legal liability, Chevron would have to, in this situation, if they change it, have to do everything feasible to make the workplace as safe as possible, and B, require all employees, disabled or not, to sign an assumption of the risk release. To sign in case I get hurt or I get injured because of my occupation, I will not sue the employer. And even this, I have to tell you, is very interesting because I have been dealing with a case where he was an immigrant and he was exposed to chemicals, and he signed a release that he will not sue the employer, and he died of lung cancer. And I have to tell you that after he died, within 2 years, his wife, the estate, sued the company, and they won. Because who signed the release? The employee that is injured. Well, now he's dead. The estate is a whole different party to what? To the release. So there is no release anymore. That means the estate can sue it. Very, very interesting. So that's happening. Employers now appear to be free to choose to not hire a person whose health safety is endangered by a particular occupational risk, thereby eliminating the worker's own need to choose. So what they're doing now, because of the overturn of this case, is if the employer sees that by hiring this person, it's a direct, not indirect, direct risk, then they don't have to hire, because the court wants the employer to be in a position of protecting the employee, because it would cost the employer more what? Benefits. Workers' comp premium would go higher. I know of a situation where a vice president was hired in a company, and after 6 months he ended up having a cancer of the liver. And I remember one of the person working in that company calling me up and say, what can we do to make sure this doesn't happen? This guy has cancer of the liver. We don't know when he's going to die. He's going to die 6 months, maybe a year. He's more in the hospital that he's working, and we cannot terminate him because of disability, but he's not producing anything, and we pay him big bucks. What can we do to make sure that this doesn't happen again? And one of the things that I have to tell you that more and more companies are doing, when you go for drug testing and they send that urine or that blood to the lab, they can find out a lot of things about you. Well, if your cholesterol is too high, they might not hire you because they don't want you to have a heart attack while you're working. This is very interesting. Something that you had to have an examination after you were hired. Don't be surprised if you're going to have to be accepted only if the examination or the drug testing is positive. That's the way they call it. Should an employer then be held responsible for a child injuries caused by a parent decision to remain in a risky work environment? So here we go in a situation that I mentioned before about the nurse being pregnant, or Johnson case about the woman policy, the policy of the company where women were not allowed to work or be exposed to lead. And suppose they have a child then that is deformed or brain damage or whatever you want to call it. And the employer told them, hey, you know, this is going to be riskier. You're going to be exposed to lead, and we cannot discriminate. So whether you're pregnant or not pregnant, men too, the same thing. If something happens, you know, we have nothing to do with it. So here's a good question. And of course, it depends from what view the case is argued. And they're a very interesting case, very. If you're going to argue from an employer's point of view, you're going to have a whole different justification. If you're going to argue from the parents that lost a child because of the risky position of the father or the mother, they have a whole different justification. And this is a very interesting case where the rule that the employer has a duty to provide employees with a safe workplace and should not be extended to an infant who was neither an employee nor employed at the work site. So in this situation, it was very interesting because he worked in a company where he was wearing a uniform, and he would be, after work, he would take the uniform at home to be washed with the clothes in a washing machine. And the thing that was very interesting in this situation is that the wife was pregnant and she gave birth to a deformed child. So next thing you know, they sued because they said there's something to do with the toxic that was in the uniform that was washing in the washing machine, just like with the other clothes. And the court says no. The employer is not liable because the unborn child or the deformed child or whatever you want to call him, it's not an employee. Therefore, I don't have any obligation to do that. And what was very interesting in this case is the dissent disagree with the court 100%. And it goes back to something that for years and years it says, wait a minute, you know, the company should have foreseen the injuries over here. Because what happened years and years ago, we had men working in a factory that had uniform, and 1956 it says, and the workers in the battery plant were obligated to change clothes at the beginning of the shift, shower and change again at the end of it, and then leave the uniform right there, and the employer would dry clean in the uniform and they could wear it the next day. And I says, if we had this in 1956, why can the employer now be liable? So this was an old case, I think it was 1989 or 1990. So don't be surprised if something like that happened today. The employer will be liable. If you have a uniform or if you have something where you're exposed to chemical, that he will be responsible even for the unborn child. Something to really think about. From a consequence or consequential, you know, are you telling me now then that the employer is responsible for the next generation with all the chemicals that we are exposed? Are they going to be responsible now? Because next thing you know, if we have an increase on learning disabled children, and we do have cases, instead of being a product liability situation, it's an employer situation. Certain choices would be unethical if they cause birth deformity to children. And one of the reasons why this is very interesting as an ethical perspective is that the employer knows. They have a research department. They know what's going on. They know exactly what's going on. And many times, you know, when somebody buys a product and the product, it causes you injury, that's a product liability case, which we're going to go on later on. But how many times then you have the warning label, but the warning label doesn't tell you everything. Or now we have the law right to know, but you really do not know everything, because I know there have been situations where as an attorney I will file an exemption where I don't want the employees to know certain things or anybody, because what makes me think that that employee is going to copy the formula and then go to another company and reveal the formula? So that we would file an exemption and asking the agency to exempt certain information that the employees does not need to know. Because one of the things also, they could panic. If they find out that we have a certain amount of I don't know, like plutonium example, next thing you know, they don't want to come to work because nobody wants to get injured, or nobody wants to have a miscarriage, or nobody wants to have a deformed child. So there's a lot of very interesting conflict of interest between the employer and also the large society and business. And is it unethical then for the employer to hire the person knowing that if the person works in this place, the condition of employment would cause him to have a brain damaged child? And at the same time, is it ethical for the parent to accept a situation like that? But then, do we have really freedom in choosing that? Do we really have all the information so that we can make a decision like that? From a utilitarian or outcome perspective, would require weighting those arms against the arms and the benefit to other stakeholders, including families of persons who accept risky job needed for food, clothing, shelter, medical insurance. So if you are arguing from an ethical perspective that is outcome oriented, to give you another illustration, for example, if I buy a cream that it's advertised that if I put it twice a day, all my wrinkles will go away. And I buy the cream, and next thing you know, I'm finding out after a week that not only the wrinkles goes away, but I'm starting to have rashes, and I'm starting peeling off, and it's ugly. Well, and I go to court, and I sue the company for, you know, whatever. And this is just an outside person. Well, if the court sees like, well, look how many people are saved, beautiful because of the cream, and it's only 10 people that their skin now are, you know, peeling off and they have rashes. But look at the other 90% of the people that they love the cream and now they have. So for the good of society, that's okay. The cream's going to stay on the market. The condition's going to not change because most people are okay. So this is where you see that the court has to balance these two things. Very interesting. In a unanimous opinion issued in June 2002, the United Supreme Court reversed the ruling in the Eckersbell case. And that's where I wanted you to know that, because it's very interesting and how they reversed the ruling by another case. Because and many times when you're going to read the dissent, even in your textbook, I want you to know that the dissent is not law. But in 5 to 10 years, the dissent might become the rule of the majority or case law. And it makes this very interesting. Emerging trends. The court upheld the validity of the Equal Employment Commission regulation, which allowed employers to refuse to hire a disabled person for a job that poses a direct threat to his or her own safety, because it found that Congress had not spoken exhaustively on threats to a worker's own health, and the Equal Employment Opportunity Commission acted reasonably in adopting the rule. Direct threat. Direct threat, and that's very, very interesting. Disability, it has to be, it's not speculative, it has to be direct threat. We have to have some kind of evidence that for the good of society, by doing that, you will get hurt. So again, after I share my perspective and from what argument I would give in this situation, now I would like you to post your argument on the bulletin board. And thank you.